Greetings, salutations, all of my fellow American sovereigns. This is the Vocational Science Freedom Saturday Night Civics and 70 class. And tonight we will be doing our third reading from a Zerohedge article titled, "What If the America You Pledge Allegiance To Isn't the One Running the Show? The Corporate Veil, America's Hidden Transformation." And tonight we will be following along with the Vocational Science of Freedom timeline document, which is available for download. Just click on the mega link that will be in the show notes for this class and download the timeline, and you guys can follow along. I encourage everyone to watch the entire VSOF timeline class. It is a continuation and an expansion as to what is being stated within this article, because this article, I would say, a good opening introduction to what's been going on and how the corporate state got created. And I think we left off at Federal Reserve and national debt structure. Okay. The Federal Reserve Act, this beast, established a central banking authority for the United States to provide a, quote, a safer, more flexible and stable monetary and financial system, close quote. According to official histories, well, right. The victors are always one that write the history, so let's not put too much positive emphasis towards that. Since the abandonment of the gold standard in 1931 in the UK and 1971 in the US, which you can thank Nixon for, most nations use fiat currency with no intrinsic value beyond government decree and public confidence. Financial commentator Martin Wolf of the Financial Times has observed that only about 3% of money exists in physical form, with the remaining 97% being electronic entries created by banks. This fundamental transformation of money from a physical store of value to largely digital entries representing one of the most significant yet least understood changes in modern economic life. Yeah, the amount of hyperinflation that has been created since the creation of the Federal Reserve is fairly shocking. But just to give you an idea about inflation, gold and silver will always stay the same amount, meaning it has the same purchasing power as it did thousands of years ago. G. Edward Griffin, the author of The Creature from Jekyll Island, very good book to read regarding the creation of the Federal Reserve, he makes this analogy where he says an ounce of gold in ancient Rome would buy a man a handcrafted belt, a handcrafted pair of shoes, and the finest toga that he could acquire in Rome. And then he takes the analogy and says, okay, if you took that same ounce of gold and you wandered into any, say, men's clothing store, and you wanted to buy a tailored suit, a handcrafted belt, and a handcrafted pair of shoes, it would still be that same single ounce of gold. So the fact that gold never changes, silver the same way, even though silver has been manipulated quite a bit, and I would say gold's manipulated to a certain extent by these huge banking controlling interests. But the manipulation of the markets aside, the actual intrinsic value of the actual money doesn't change. Whereas I think since 1913, the buying power of a dollar, which was back then, which was properly a Spanish milled dollar of a certain so many grains of silver. I can't remember exactly what it was. It was a little bit under, I think, a troy ounce. And as that was stated in the Banking Act. And then you take that, what would that dollar buy in 1913? And then take that forward as to what one Federal Reserve note, what we call a dollar, but really isn't, what that would buy now. And it's ridiculous as far as the inflation is concerned. And inflation, as has been said by wise men, is simply a hidden tax on people for the use of money. Well, whose money are we using? We're using monopoly money created by the international Luciferian occultists. And it's not like this war is new as far as the creation of money out of nothing. One of the most significant historical bits of history, as far as America is concerned, regarding the war, was with Andrew Jackson, when he vetoed the Second Bank of the United States. And for reference purposes, I don't have it up, but I highly suggest that everybody go to what's called the Avalon Project. I believe it's supported and funded from Yale University, but there's basically just one scholar who kind of created this whole entire website. And in the Avalon Project, you can find a lot of works all the way through time as far as law is concerned, very important works. And I know that Jackson's veto of the Second Bank of the United States is on the Avalon Project. It's worth reading. It's not that long. It's very interesting. And it will give you a real sense as to how much Jackson hated these people and why, and for good reason. And that he never was going to allow them to do what they eventually did do in 1913. He wasn't going to have it. And they tried to kill him, of course. And they tried to kill, well, they didn't try to kill, they did kill Garfield. Garfield was the president prior to this establishment of this monster. And Garfield also wanted nothing to do with these people and did not want to have a central bank as well, because he fully understood what it would mean. And so they shot him in the back. I think pretty much all of the presidents that have been shot and killed, they all had to do with the creation of money. They all had to do with central banking. Garfield, Lincoln, JFK, clearly. Of course, JFK had other issues as well, but he was the one that created the United States note, which was a debt-free currency, just like, I shouldn't say just like, but in akin to what Lincoln created, which was called the greenback. Both of these were debt-free currencies and were outside the purview and the control of the international banking cartel. So now to continue. As observed that only 3% of money exists in physical form. Okay, we read that. However, primary documents from the congressional record reveal serious concerns raised during its formation. The timing of this legislation is particularly significant. Treasury records confirm that America was experiencing financial difficulties during this period, making the country, and this was the time just before 1913, there was a sort of a stock market crash, which was obviously created and fomented by the bankers themselves to perpetuate the Hegelian dialectic on everyone, which is create the problem, wait for the reaction, and then come along with a solution, also known simply as problem, reaction, solution. And from that, again, that happened during Garfield's time. That was what they did prior to scare everybody, to say, oh, we need this system. Oh, we have to have a central bank, or else these things are just going to keep continuing. Well, of course they are when you're the one creating them, and you're going to keep creating them until you get what you want. So the Federal Reserve Act in 1913 established a system in which private banking interests rather than elected representatives would now be able to increasingly dictate monetary policy. Right, totally control it. While no single document explicitly confirms a private acquisition of U.S. financial sovereignty, the establishment of the Fed can arguably be seen as just that. Right, because then all of the money was created by private bankers. As well documented by economist Murray Rothbard in The Case Against the Fed, the Federal Reserve System created a mechanism through which private banks gained unprecedented control over national monetary policy while maintaining the appearance of government oversight. Notably, the national debt expanded dramatically following the Federal Reserve's establishment. Exactly, which is exactly what I was getting at, along with the inflation. Now, I have not read this particular book. Now, the way that G. Edward Griffin explains it, and I'm going to try not to butcher this, he basically explains the Federal Reserve in an aspect of what is and what is not. So the Federal Reserve is not what it, and of course I'm butchering this horribly, but he basically gets into the point that there are some things that you see that they say they're one thing and they're actually something else. There are other things that say that they are the thing that they are. And then there are things that say that they're something and they're not even the thing that they are. And basically the Federal Reserve is what G. Edward Griffin is kind of getting at in a nutshell. The fact that the Federal Reserve gives you an idea that this thing is federal to begin with, which it isn't, it's private, and that has some sort of reserves, which it doesn't, because they create the money out of nothing. So it's not what it is, and it's not even named for what it is. So the whole entire thing was as we usually see through what the attorney does, it is a manipulation of vocabulary to make you think that something is when it is actually not that thing. Okay, so to continue, Jekyll Island meeting, documented secrecy. As financial historian J. Edward Griffin documents in The Creature from Jekyll Island, the Federal Reserve meetings were conducted in extreme secrecy. The Jekyll Island meeting occurred November 22nd through the 30th of 1910, with specific participants including Senator Nelson Aldrich, Rockefeller's son-in-law. That little bastard was the guy who orchestrated this whole thing. The private train car to take them all down there. Because back then, it was just trains. Nobody was riding in cars. But people had private train cars that they would attach up to the backside of the train. And that's where all of these little bastards decided to sneak in and pretend they were different people, and some of them wore disguises. And they all took on fake names during the trip. Because obviously, if the world found out, if all of America found out what they were up to, I'm pretty sure they would have been executed for doing what they did. So secrecy was not just because they wanted to talk, but because their very lives would have been at risk. So anyway, Aldrich, Rockefeller's son-in-law, Henry P. Davison, which is J.P. Morgan's senior partner, Paul Warburg, which representing the Rothschilds, and Kuhn Loeb and Company, which we talked about a little bit last time. Frank Vanderlip, president of National City Bank, representing William Rockefeller. Charles D. Norton, president of the First National Bank of New York. And A. Pyatt Andrew, assistant secretary of the Treasury. Sutton's analysis in the Federal Reserve conspiracy calculated that the Jekyll Island meeting participants represented banking interest estimated by Sutton to represent approximately 1/4 of the total wealth of the world at that time. This concentration of financial power in a clandestine meeting, designing what would become America's central banking system, reveals the magnitude of this transformation of monetary sovereignty. This gathering of government officials and private bankers collaborating to design the nation's monetary system was later confirmed by a participant, Frank Vanderlip himself, who admitted in the February 9th, 1935 Saturday Evening Post, quote, "I was as secretive, indeed, as furtive as any conspirator. I do not feel it is an exaggeration to speak of our secret expedition to Jekyll Island as the occasion of the actual conception of what eventually became the Federal Reserve System." Close quote. Right. This secrecy extended to the bill's passage, rushed through Congress on December 25th, 1913, just before Christmas, when many representatives, I believe it was 75%, had already left Washington, ensuring, I would say, no debate. Let that sink in for a moment. The architects of our money system explicitly compared themselves to conspirators working in secret to reshape a nation's financial foundation. When I first read Vanderlip's admission, I had to check multiple sources to believe it wasn't fabricated. Yeah, because this guy has probably the first time he's experienced this level of fuckery when it comes to the government. After you read into history quite a bit and go pretty far back, nothing surprises you anymore. But to continue, actually, I'm going to bring up the timeline doc for a second and connect in some of these other aspects with the Federal Reserve. Okay, so this was the lead up. We talked about this last time, the 1910, and for those who don't remember, the CUL references are the Council on Uniform Laws, which later got renamed into something else. But this is basically the attorneys preparing everything prior to the Federal Reserve coming into existence. Okay, so Federal Reserve Banking, private association of European and American banks calling themselves the Federal Reserve, began controlling the Governmental Services Corporation known as the United States Incorporated and its quote-unquote state franchises, which are not exactly franchises, they're just conquered territories, as we discussed last time, and began operating such familiar agencies as the United States Department of Agriculture and the United States Department of Transportation as private, for-profit businesses without telling anyone. They exercised the government powers they didn't really possess in a vast fraud scheme in collusion with members of Congress to institute a fiat monetary system and misuse their position of trust to put competitors out of business, set up monopolies, rig commodity markets, and commit other acts of blatant self-interested criminality and fraud. And this gets, again, back to Mandel Edward House. Now, I did not read this last time. I will read this. But again, the totality of this quote is totally laid out in the class that I did on House. And on YouTube, it's called Learn How the Republic Has Been Destroyed and How You Can Take It Back. It's literally the first video in the self-awareness playlist quadrant. And I break down this entire quote, which I will read to you now, but however, it's thoroughly detailed within that class. So I'm just going to read it. I'm not going to elaborate on it. You can watch that other class if you like to literally learn what each and every word in this quote actually means and what he actually did with Wilson. And this was basically a letter from House to Wilson, I believe. So, quote, very soon, every American will be required to register their biological property in a national system designed to keep track of the people and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Every American will be forced to register or suffer not being able to work and earn a living. They will be our chattel, and we will hold the security interest over them forever. By operation of the law merchant under the scheme of secured transactions. Americans, by unknowingly or unwittingly delivering the bills of lading, birth certificates, to us will be rendered bankrupt and insolvent, forever to remain economic slaves through taxation, secured by their pledges. Because what's a pledge? A pledge is a one-sided thing. It's not like a contract. A pledge is something when you do it, the other side doesn't have to have any other part of the agreement. You just do it out of your own volition. Even though the vast majority of what they're talking about here, you don't even know that you're doing it. But I digress. All right, to continue with the quote. They will be stripped of their rights and given a commercial value designed to make us a profit, and they will be none the wiser. For not one man in a million could ever figure our plans. And if by accident one or two would figure it out, like we have in our arsenal plausible deniability. After all, this is the only logical way to fund government. By floating liens and debt to the registrants, stop registering your fucking property in the form of benefits and privileges. Think about property tax and getting government schools. This will inevitably reap to us huge profits beyond our wildest expectations and leave every American a contributor to this fraud, which we will call social insurance. It was eventually called Social Security. Without realizing it, every American will insure us for any loss we may incur. And in this manner, every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope for their redemption. Their redemption. And we will employ the high office of the president of our dummy corporation to foment this plot against America. Close quote. Again, if you want all of that broken down, watch the Mandel Edward House class. Okay. Back to the article. While conventional financial historians acknowledge these meetings took place, they typically frame them as necessary collaboration between public and private sectors to create a more stable banking system, following the panic of 1907, which, as I said before, was their own creation to make sure that this thing would go through. The Federal Reserve's official history emphasizes its creation as a response to repeated financial crises rather than as a transfer of sovereignty. Well, they didn't transfer any sovereignty at all. They transferred the capacity to print the money. We, the people, are sovereign. Banks are not sovereign. Corporations are not sovereign. Even governments are not sovereign. Only people are. But to continue. However, the documented secrecy of these proceedings and the subsequent exponential growth of national debt warrant deeper examination of whose interests were ultimately served. Congressional warnings and debt expansion. Congressman Charles Lindbergh Sr. warned on the House floor, quote, "This act establishes the most gigantic trust on earth. When the president signs this bill, the invisible government, by the monetary power, will be legalized." Close quote. Yes and no. Technically, there's no constitutionality to what they did. The Federal Reserve is an unconstitutional monstrosity. We, the people, in the Constitution, vested, not permanently gave to, not forever gave up, our power to determine the value of money and to print and determine the value of money thereof, such and so forth. We vested that power to Congress. There is no place in the Constitution that states that Congress can vest that power to somebody else. So from its inception, sorry, it's unconstitutional. Doesn't work. It's just that nobody's suited out of existence, or if anybody has tried, their wives die or their children die or they die, and that's the end of it. And I can think of plenty of other people that happened to. James Trafficant is a good example of that. He was another congressman that was clearly warning not only about the Federal Reserve, but also about Israel. Now, there have been other people that have warned about the Federal Reserve. Dr. Ron Paul, obviously, has spoken a lot about ending the Federal Reserve. And hopefully, if Doge was serious and Musk was serious about bringing him on to audit the Federal Reserve, I think that'd be a great start. I think the book should be opened up. I didn't hear anything back about where our gold is. I don't know if that particular venture by Doge and Musk has been finalized, finished, or even gotten started for that matter. But that's going to be a critical thing to find out. Where's our gold? Because I'm pretty sure it's not in Fort Knox. And since the magical collapse of Building 7 on a date of 9/11, there was a bank heist there because there was a lot of gold, from my understanding, in that building. And then it wasn't there. So we'll see how that plays out. Okay. To flip back over to the timeline, 1913 January banking history. On March 4th, Woodrow Wilson is elected to 28th President of the United States. Shortly after he is inaugurated, he is visited in the White House by an Ashkenazi Jew named Samuel Ottomeyer of law firm Guggenheim, Ottomeyer and Marshall, who tries to blackmail him for the sum of $40,000 in relation to an affair Wilson had whilst he was a professor at Princeton University with a fellow professor's wife. President Wilson does not have the money, so Untermeyer volunteers to pay the $40,000 out of his own pocket. Oh, how generous of him. To the woman Wilson had ended the affair with, on the condition that Wilson will promise to appoint the first vacancy on the United States Supreme Court with a nominee recommended to Wilson by Untermeyer. Wilson agrees to this. He is hereinafter controlled completely like the clown that he was. Get the flavor of Epstein client list here? Okay, same idea. So, President Woodrow Wilson, in his book, wrote in The New Freedom, and remember this was happening almost a century ago, so just remember that this is just the top of the iceberg, right, regarding what we know. He quoted, all right, Wilson said, quote, "Some of the biggest men in U.S. history in the field of commerce and manufacturing are afraid of somebody, are afraid of something. They know that there is a power somewhere, so organized, so subtle, so watchful, so interlocked, so complete, and so pervasive, that they had better not speak above their breath when they speak in condemnation of it. What does that sound like? Yeah. We have been dreading all along the time when the combined power of our high finance would be greater than the power of government. We have come to be one of the worst ruled, one of the most completely controlled and dominated governments in the civilized world. No longer a government of free opinion, no longer a government by conviction and the vote of the majority, but a government by the opinion and duress of a small group of dominant men that wear little hats. That was my addition. We are in a new world. Behind the whole subject, of course, is that truth that in the new order, what? Government and business must be associated closely, and we stand in the presence of a revolution, which will come in a peaceful guise. After 2 world wars, Israel sucking us dry for 100 years, I don't really see how that's peaceful, you son of a bitch. But if I knew where his grave was, I'd piss on it. But I digress. Back to the article. All right. Questions of legitimate debt. Such historical developments prompt important questions about the legitimacy of national debt concerning to what jurisprudence experts would later term odious debt. It's all odious. Because it gets created out of nothing, it gets borrowed into existence from the United States Federal Corporation, and then Congress turns around and says, you have to pay for our debt. Right. Because remember, everyone, it's Congress that's bankrupt. Not you, not me, Congress. But to continue. A doctrine formerly developed by Alexander Sack in Laissez-faire des I can't even begin to pronounce that much French. Sorry, guys. Establishes that debts incurred by a regime for purposes that do not serve the interests of the nation do not oblige its people. Exactly what I just said. Income tax in the UK began in 1799 as a temporary measure to fund the Napoleonic Wars. It was withdrawn in 1816, but reintroduced in 1842 and has remained ever since, despite its origins as a wartime emergency measure. The perpetuation of supposedly temporary financial measures is a pattern worth examining in the evolution of state financial structures. Right, because it's always done by a ruse of some sort, an emergency of some kind, a disastrous thing that we must take care of. And it's always supposed to be temporary. However, it never turns out to be temporary, but that's history. As noted by historian Martin Daunton, in Trusting Leviathan, The Politics of Taxation in Britain, 1799 to 1914, many of our modern financial institutions began as emergency wartime measures that were later normalized. Right. While Sack's doctrine of odious debt was traditionally applied only to authoritarian regimes, law professor Odile Lignou, probably butchering that as well, at Cornell Law School, has expanded this analysis in, quote, Rethinking Sovereign Debt. Lignou questions whether even democratic nations truly maintain meaningful public consent for certain financial obligations, which of course they don't. A democracy never has control over that, particularly those imposed through structural adjustment programs. Right. This broadened framework raises intriguing questions about American national debt. Treasury documents that show that U.S. national debt is uniquely structured in ways that suggest similar principles of questionable consent might apply to our own financial obligations. The mechanisms by which this debt is collateralized remain largely unexplored in mainstream economic discussions. Yeah, I don't even want to get into collateralized debt obligations and how reverse pyramid this whole entire idiotic, dark Luciferian, occult money structure monster is, and how many of the chips are certainly going to fall as the whole house of cards comes crumbling down, and the only safety is at the absolute bottom of the inverted pyramid, which is all the gold and silver on the planet. And if you do not own gold and silver yet, I don't care how rich you are, I would suggest taking at least a fourth of your entire net worth and converting it into gold and silver, just to be on the safe side. Because when all the rest of this funny money nonsense stupidity comes crashing down, that'll be the only thing that will have valuable consideration, not only as per law, but as per ancient history. And sure, I get some of the arguments that some of the people in, the crypto realm make, but at the same time, those cryptos can be just as easily destroyed or taken over by brute force in many cases, and most likely won't last in a global depression. Just highly unlikely. And of course, if anything, even close to resembling I was trying to remember the name of that. There was a celestial event, but basically an enormous solar flare hit in the late 1800s. The only thing that was up back then was basically telegraph lines. But anyway, the point of bringing this up is that solar flares hit. Regular thing. They do that on a regular basis. Now, the level of that flare, what it did was there was so much electromagnetic energy that made its way through and got through the electromagnetic field of the Earth that it basically got itself flying back and forth across long lines of metal, telegraph lines. Well, it electrified them so much that they heated up so much that they melted and fell off the poles. Okay, that can happen tomorrow, people. Sorry, there's no human possibility to control the sun. Sorry, just not possible. We are woefully subject to the absolute powers of natural law. And if that were to happen again, you're not going to be exchanging anything digitally. Zero, nothing, including whatever cryptocurrency you may have, because everything's going to get fried. So you should have things on hand just in case that does happen, because we're way overdue for another event like that. Because they happen about every 175 years. Thank you, Spectre. Carrington event. They happen about every 175 years, 150 years, and we are quite a ways overdue for another one of that size to happen. So just take that with a grain of salt. But again, if you want to be truly protected, gain skills, gain seeds, gain knowledge, and store real books, meaning physical books, and get yourself some gold and silver, because you never know what's around the corner, aside from what these Khazarian, dark Luciferian, occult fuckers want to do with our own money supply. The universe has something to say about it as well. So, all right, to continue. These documented transformations in banking authority collectively represent a profound shift in where monetary power resided. While 19th century Americans understood money creation as a function of elected representatives, these sequential legislative changes gradually relocated this power to institutions operating at arm's length from electoral accountability. This transition in financial sovereignty laid the groundwork for even more consequential changes in monetary standards that would soon follow. The gold standard transition. The transfer of financial authority from elected officials to banking interests accelerated significantly with the Independent Treasury Act of 1920. This legislation, found in the United States Statutes at Large, Volume 41, page 654, now codified at 31 U.S.C. 9303, explicitly abolished the offices of Assistant Treasurers of the United States and authorized, quote, the Secretary of the Treasury to utilize any of the Federal Reserve banks acting as depositories or fiscal agents of the United States for the purpose of performing any or all of such duties and functions. Basically, transfer it all to them. Here, just have it. Kind of crazy. This represented a profound shift. Yeah, you betcha. As the Act states, the Secretary could transfer these functions, notwithstanding the limitations of Section 15 of the Federal Reserve Act, which had originally restricted Federal Reserve banks to only specific fiscal agent functions and maintained certain Treasury independence. Not anymore. They just get it all. Here, international bankers, here, just control everything. Again, totally, completely unconstitutional. The language of the act demonstrates how banking functions, once performed directly by Treasury officials, were legally transferred, well, I would say unconstitutionally, usurped to the Federal Reserve System less than 7 years after its creation. Don't tell me they didn't have that in the works prior to. So, House Joint Resolution 192. And this is going to get into some, well, unless he gets into it, I'm not going to get into it. But anyway, there's been a lot of stupidity around HJR 192 over many, many, many years that people think there's some sort of remedy there. But I don't want to get into all that because unless he does. So anyway, let's just see where he goes with this. All right. House Joint Resolution 192, 1933, which suspended the gold standard during the Great Depression as a supposedly temporary emergency measure, contains language that some legal analysts interpret as fundamentally altering the relationship between citizens and government debt. By removing gold backing from currency and prohibiting payment in gold, this resolution created a system where, as some monetary historians argue, debt instruments became the only available medium of exchange. The evolution... See, that doesn't even make any sense. What do you mean? Became the only available medium of exchange. What, they instantaneously just, decided to magically fucking disappear all of the gold and silver and all the rest of the precious metals off the entire face of the planet? Of course not. It's called a choice. It's called consent. What did Jefferson say? The just powers of government are derived by what? The consent of the governed. Okay. No consent, no just powers. It's really that easy. It's really that simple. And no one needs to make it any more fucking complicated than that because it isn't. So if you want to have a medium exchange that you exchange value with somebody else in gold and silver, fine, then do it. And stop having mediums of exchange with any other corporation, or at least minimize it as much as you possibly can with anything that deals with plastic or digital garbage. Right? Cash is king, or at least it used to be, until Nixon dropped the gold standard. But you can still exchange things in gold and silver. There's nothing stopping you from doing that. But anyway, get off my rant. The evolution from commodity-backed currency to pure fiat money followed a clear timeline of increasing abstraction and coordination between financial centers. Good. I'm glad he made his own little timeline. This is important. Timelines are important, people. All right. 1913 to 1933. Federal Reserve Act, creating a central banking system modeled after the Bank of England. Right. Also modeled after a previous central bank that we had and then got rid of. With founders like Paul Warburg maintaining direct ties to European banking interests. Yes, the Rothschilds controlled this whole fucking thing. While currency remained officially gold-backed, the governance structures of Washington and London's financial systems became increasingly aligned. Right, because this was the perpetuation of what they wanted to do, they meaning the international Jewry, wanted to do, which was to put America back under the control of England, and specifically the Rothschilds. You know, obviously, we have a lot of quotes from said bastards. One of them being, send them back to colonial status was something that Rothschild once said, I believe, just prior to the War of 1812. And they've always wanted their central bank here so that they can control us completely, just like they controlled England. Because England has been controlled ever since they have their central bank set up, which was what literally perpetuated the entire English Empire, was their manipulation. And, well, I don't want to get into colonialism. I'm digressing. All right, next one. Number 2, 1933, 1934. Executive Order 6102 and the Gold Reserve Act ending domestic gold convertibility, requiring citizens to exchange gold for Federal Reserve notes. Wait a second. Is that the same executive order that I have hanging on my wall? Hold on. This might have been the one. This might have been the one that they posted in all of the post offices. Actually, probably is, come to think of it. Okay, so basically what this did is they ordered everybody, but the executive order was very interesting. Well, actually, you know what? I'll just click on it because we should be able to go read it. So, page not found. Oh, imagine that. Huh. Why is that not surprising? Anyway, I could go rip it off the wall, but anyway, you guys could probably go find it. The point is that I wanted to make the point about that this executive order, it starts off by saying that, and I can read some of it from where I'm sitting here. All persons are required to deliver on or before May 1st, 1933. Okay, first off, right off the bat, all persons, not people, persons, infants. We're dealing with infants here again. So they said all the infants have to turn in their gold by what? On or before May 1st, 1933. What is May 1st? May 1st is the highest Luciferian holiday. Totally. Without question. That is their highest holiday. So it says, on or before May 1st, 1933, they must turn in all gold coin, gold bullion, and gold certificates, now owned by them, meaning the infants, to a Federal Reserve Bank, branch, or agency, or to any member bank of the Federal Reserve System. And that's all the bigger the print is right there. And then it goes into the smaller reading, which I would have to be a hawk to be able to read from here. But point is, what were they doing? Demanding the infants to turn in their gold. Can't demand a sovereign to do that. The sovereign will just fucking shoot you. Right? So anyway, this is the aspect of using Roman civil law to come over the top of and pretend as if these orders and things have any full force and effect against an actual sovereign. They don't. Unless you consent to them. And again, that'd be back to Jefferson, but I continue. All right. So this period saw increased financial coordination between the Vatican Bank, right, founded in 1942, and Western banking interests as gold flows centralized among these institutions. Exactly. Because this is all backed. If all of this, you got to go farther and farther back. All this is started going all the way back to the cult of Rome, which goes back to certain aspects of Rome itself, which I won't get into. But it goes back to the Venetian black nobility as well. And the first unum sanctum and all of the rest of that shit. The first testamentary trust, which I think I covered either the first episode of this or the second episode. So I won't rehash that. All right. Number 3, 1944, the Bretton Woods Agreement established the dollar as the gold reserve currency with formal mechanisms for coordination between these financial centers. The International Monetary Fund and World Bank were created with governance structures that ensured London maintained significant influence while the Vatican secured privileged financial relationships. If you ever look up how the IMF works off of what's called special drawing rights between these different countries. Anybody want to take a wild guess what they're drawing off of and what the special drawing rights actually represent? Yeah. The more intelligent and well-learned of you will already know the answer. Number 4, August 15, 1971. President Nixon unilaterally terminated dollar convertibility to gold, completing the transition to fiat currency. This final step cemented a global financial architecture in which the 3 power centers operated through interlocking directorates and financial relationships independent of gold's constraints. Now, I've always wondered why Nixon did this, because Nixon was definitely no lover of the Jew. I can guarantee that. There's plenty of quotes of him talking about that. But at the same time, as I recall, I believe Nixon was Nixon a Mormon? I can't remember. I know Nixon had dark occult connections. Of course, they all have. But he wasn't really a lover of the international banking cartel. So I don't know why he actually did this, unless they basically tricked him into saying, well, if you do this, then they won't be able to do X, Y, Z or something. But ultimately, what the author of this article just wrote, I tend to agree with. It finally cemented a global financial architecture. So let's see what else I got in the timeline doc. See if there's anything else in here that I want to go over. Okay, so this deals with the 16th Amendment. I don't know if he's going to get into that. I won't. If he won't, 1913, April 8th, the several states presumably voluntarily surrendered and consented to deprive themselves of their rights of suffrage by the imposition of the 17th Article Amendment to the Constitution, such amendment being an abrogation of the intent, directive, legal construction, and relevant structural conditions set forth in Article 1, Section 3, and in Article 5, providing that no state, without its consent, shall be deprived of its equal suffrage in the Senate, which is exactly how we saw the 14th Amendment come into existence. It should be noted that when the people of the several states chartered the United States as an admiralty jurisdiction, it was not the legislative intent of the September 1787 Congress to put into effect a self-destruct mechanism, such as could possibly make a proposed constitutional amendment to the several states where, upon its ratification through any mechanism, the constitutional prohibitions regulating the United States would somehow cease to exist. True. The Congress itself has never had the power to modify the very Constitution that created the Congress itself. True. And any lawful modification done by way of amendment can only be made through the legislation of 3/4 of the states or by conventions of 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. Right. The Congress had been delegated only those 17 powers enumerated in Article 1, Section 8. All other powers not vested by the Constitution in the government of the United States or in the department or officer thereof are specifically reserved to, guess who? We the people. For their exercise of primary jurisdiction over their representative governments. Right. Okay. So just stating that one more proposed amendment didn't actually properly go through either. There's a timeline here for Federal Reserve Act. So House Joint Resolution was proposed on August 29th, 1913. Committee consideration by Banking House, Senate Bank, and Senate Banking. Passed the House on September 18th, 1913. Passed the Senate on December 18th, 1913. So it went September and then December. And then reported by the Joint Conference Committee on December 22nd, 1913. Agreed to by the House on December 22nd, 1913, and the Senate on December 23rd, 1913, and then signed by Wilson December 23rd, 1913, like the same day. Some of the recent evidence has come forward as to who really owns the Federal Reserve. They are the following banks: Rothschild, Bank of London; Warburg, Bank of Hamburg; Rothschild, Bank of Berlin; Lehman Brothers of New York; Lazard Brothers of Paris; Kuhn Loeb, Bank of New York; Israel Moses Schiff Banks of Italy; Goldman Sachs of New York; Warburg Bank of Amsterdam; Chase Manhattan Bank of New York. These are all Rothschild banks. Yes, exactly. March 31st, J.P. Morgan, alleged owner of the J.P. Morgan banking empire, dies. Okay, that would be 1913. He is thought to be the richest man in America, but it will be revealed he only owned 19% of J.P. Morgan companies, the other 81% owned by the Rothschilds. Exactly. And just to make a rant for no apparent reason, some idiot the other day, I can't remember on what social media platform, was trying to argue with me that, no, it's not the Rothschilds. No, it's the Rockefellers own everything now. I was like, will you shut the fuck up? I'm like, the Rothschilds are so beyond the Rockefellers. They're inside the houses of several different monarchs. They've had half the planet's wealth for quite a big period of time. So don't give me this shit that, the Federal Reserve is now controlled by the Rockefellers. Shut up. Don't want to hear it. Anyway, to continue, back to the article. While the chart shows increasing digitization, the fundamental issue isn't the digital format itself. The concept behind technologies like Bitcoin, creating digital assets with properties that could potentially resist centralization, illustrates that digitization alone isn't the problem. The core concern is money becoming mere accounting entries in a centralized ledger that can be adjusted without the constraints that physical gold once imposed. Right. As in having a actual reserve requirement that doesn't exist anymore. Reserve requirements when this whole bloody thing got started were, I think, 32 to 1. So they could create into existence $31 for every dollar of gold and silver that they actually had in the vault. And you couldn't go past that. That was by law. And then they figured out just a way to go past it, basically. So this chart, let's see if I can blow this up at all. Okay, so abstraction of money, 1913 to present. Evolution of physical value to debt instruments. 1913, 100% go back. 1933, 25% cash, 75% go back. 44, 60% cash, 40% gold. 71, 75% digital entries. This just came out of nowhere. 15% cash, 10% gold. Today, 97% digital entries. 1913, Federal Reserve. 1933, executive order to steal the gold. 1944, Bretton Woods. 1971, Nixon stole the rest of it. Today, digital dominance. So, right. How can you pay a debt with a debt? You can't. It's called discharging. You don't pay anything. Perhaps no better chart illustrates the tangible impact of its monetary transformation than the divergence between productivity and worker compensation that began precisely when the United States abandoned the gold standard completely in 1971. Imagine that. What the fuck happened in 1971? Well, here you go. We got growth in productivity and hourly compensation since 1948. So we go back 48, follows, stays the same, and then whack. Right at Nixon. Compensation, way down. Productivity, way up. Now, could some of that possibly be attributed to technology? I suppose, a little bit. However, that's, well, there's no such thing as coincidence when it comes to that. Okay, source. When the Federal Reserve notes replaced gold-backed currency, it created a system in which, as monetary historian Stefan Zarlegna, probably butchered that too, notes, we are, quote, being asked to pay debts, but all we are given from the system is debt notes. Right. AKA fiat money to pay back those debts. This monetary paradox presents a fundamental contradiction. How can you pay a debt with a debt? Exactly. As I said, you don't. You discharge it. Legal framework transformation, which means, and to make a more strong point about that, when you go and give somebody 100 worthless Federal Reserve notes and they give you a bike or whatever the hell it is that you just quote unquote bought from them, the transaction itself, because you didn't give them lawful consideration, automatically does not transfer the ownership of that bike to you. Sorry. That's why they want you to register everything. And that's why everything with a serial number on it has already been registered with either a manufacturer's certificate of origin, which has been registered at some Secretary of State because the government is actually the thing that owns all these things, not you, which is why they can tell you to, wear your seatbelt and buy insurance on the thing that's not yours, and what you can do with your own body and what you have to do with your children and la, 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 la. It stems from this. It stems from the fact that you don't actually own anything, because you never paid for it, technically, at law. There's no consideration. You didn't pay for it. Therefore, how the fuck can you own it? Answer, you can't. All right, to continue. Legal framework transformation. Shifts in legal philosophy. The documentary discrepancies when comparing the Constitution to subsequent legal frameworks, like Roman civil law, maritime amnesty, the law merchant, military, ecclesiastical, need I go on? Particularly the Uniform Commercial Code, right, which is just the law merchant on a global scale, by the way, that now governs most commercial transactions, reveal significant shifts in legal philosophy. Legal historians have documented how common law principles were gradually replaced by admiralty and commercial law concepts. Bingo. Welcome to the Vocational Science Freedom Timeline class. Erie Railroad Company versus Tompkins, 1938, fundamentally altered the application of law in federal courts by ruling that federal courts must apply state common law rather than federal general law in diversity cases. Scholars have noted this represented a significant shift away from common law principles toward commercial and statutory frameworks. Exactly what did I just say a minute ago. The running over of all of us by Roman civil law and the law merchant. Okay. Because when you're playing with stupid monopoly money, what are you doing? You're playing with negotiable instruments. Okay. What does that make you? A merchant. And then if you're going to be playing with these things, you're considered to be an expert in what you're doing. Okay. So you've set yourself up for failure because you're dealing in a world that you have no idea how it operates and for what reasons it's operating. So anyway, to continue. Within this evolving legal landscape, Title 28 U.S.C. 3002 15A, my favorite U.S. code. Well, maybe not. Probably Title 1 U.S.C. subsection 8, definition of person, is probably my favorite one, but this is probably the second. Provides a particularly interesting definition, stating that United States means a federal corporation. Bingo. Close quote. End of discussion. Have a nice day. Wow. Conventional legal interpretation views this as a simply defining the United States' ability to function as a legal entity for practical purposes. Some researchers suggest it might have deeper implications for sovereignty. You think so? You have corporate governance. For fuck's sake, wake the fuck up and stop consenting to their fuckery. Enough's enough. This distinction between legal and lawful reflects a philosophical tension between natural law concepts and statutory framework. It also reflects a philosophical difference between common law and equity. Because in equity, guess what you do? You split the title of everything in equity. You have a legal title and you have an equitable title. The legal title is the person that actually owns the damn thing. The equitable title is the one that gets to use it. Otherwise known as the infant that has to go register the thing. And then you get a certificate of title, which is like monopoly money for an actual real title. So you have monopoly money in place of gold and silver, and then your monopoly titles are your certificates of title. It's not the actual title. That would be the manufacturer's certificate of origin. That would be the real title. No, they give you a certificate of title, little baby. So you can walk around and tell your black-booted authority master, Mr. Pig, oh yeah, I'm a good infant. Look, I have it in my glove box. Okay, well, you get to pay some fines, little baby, because you didn't have your seatbelt on. Right? Anyway, this distinction between legal and lawful reflects a philosophical tension between natural law concepts and statutory frameworks that dates back centuries into Anglo-American jurisprudence. Again, timeline course. As legal historian Albert V. Dicey noted in his seminal work, Introduction to the Study of Law of the Constitution, 1885, lawful acts align with common law traditions and inherent natural rights. True. While legal acts derive their validity purely from statutory law created by the state. Okay, that's correct, because there's only two origins of law. And if you want to learn all this, go watch the ins and outs of court and go watch the totality of law class. Also, very important to understand this stuff. So there's only two origins of law, common law and statute. That's it. Now, there's other kinds of forms of law. There's other jurisdictions of law, but that's not what I just said. I said there's only two origins of law, common law and statute. And you, my fellow American sovereign, are not bound by statute except by consent, contract, pledge, or basically presumption, which is how they get you most of the time, because they presume that you're XYZ and you don't rebut the presumption. Okay? Is that clear? Good. The dual identity paradox, person versus property. Perhaps the most profound aspect of this potential transformation lies in how it redefines individual identity itself. Legal experts examining Treasury regulations and birth certificate processes have identified a curious phenomenon, the creation of what appears to be a dual identity for every citizen. Okay, it's not a dual identity. It's the difference between your estate, the name of your estate, being administered, and you acting as a trustee of that estate. Okay? So this gets into a whole problem with what people do not understand about this. There has been this perpetuation through the study of this information for decades, that somehow or another, the all capital letters name is a corporation, and that the government created a corporation for you. They didn't. Okay. Now, some people like to say, well, that's a legal person. Okay. That's not technically incorrect, but it's the wrong way to think about it, because there's a lot of things that are legal persons. A corporation, yes, is a legal person. A trust is a legal person. An estate is also, in a sense, can be a legal person, particularly when you force it through bankruptcy. And go read any bankruptcy case. You'll see very clearly how that's laid out. But it's the estate, okay? It's the estate that they're saying is bankrupt. But anyway, so I'll open up this little thing and we'll see what's right and see what's wrong here. Okay, so dual identity, the bifurcation of personhood in modern legal frameworks. Natural person, again, don't ever use the word natural person. That's, again, another retarded thing to do. All you just said is that you're a natural baby. You're one of the people, okay? So one of the people of several states of the American Union is the more extended version of that, but you are a people, not a person. Government derives power from we the people, not persons. Name and title case, John Doe. That would properly be, if it's two names, or meaning if it's got a middle name, or he has a middle name, it'd be John Henry, House of Doe. You can put a hyphen between John and Henry if you want to. And you can put a colon after Henry if you want to. You're John Henry, and you are of the House of Doe. You have to be of your own house, because if you are not of your own house, you are in their house. And if you're in somebody else's house, you are subject to their law. Got it? Good. Characteristics. Born with inherent rights. True, as long as you're dealing with people. Exist under common law. I wouldn't say under. You're at common law, because you have the capacity to create law when you're a sovereign. Rights antecedent to the state. True. Your rights exist before the state and government exist. Physical living being. True. I could elaborate on that, but that's okay. That's fine for now. Self-determined sovereign entity. Right. True. As long as you're people. Again, get this idea of natural person out. Don't ever say that word. Legal person. Government. Privileges too. Name all caps. John Doe. This is your estate. Or I should more correctly state, whatever the name on your birth certificate is, that's the name of your estate. It might be in all caps. It might not be in all caps. I know a lot of older men whose birth certificates, only their last name is capitalized. And some of my mentors have argued that it's the last name that the government wants to attack, possibly copyright it, which there was a guy one time, and I don't mean to digress here because it all kind of connects in. There was a gentleman one time who was doing deep research into mortgage fraud. And he found out that through the mortgage documents, like the closing documents and what they do and whatnot, that the banks and the attorney were basically making copyright of your last name. Now, that's of course not on the fundamental government side, but if it does follow through, I could see how it would follow through, or I could see that they would do it. Meaning, if they could do it for a mortgage contract, I don't see why they wouldn't originally do it at the creation of the birth certificate itself. Now, again, that's just theory. That's like my theory. And I don't have any problem with theory. As long as it's logical and as long as you eventually can lock it down, prove it. Okay, so to continue here. Created by state registration. Well, it's created by contract. It's created by the birth certificate. So the mother and the father signing the birth certificate. Now, really only the mother has to sign it, because the birth certificate contract clearly delineates that the mother and the father don't have the same name. It's always the mother's maiden name on the birth certificate, which is why it looks like on the birth certificate that the child is what? A bastard. And if you're a bastard under the common law, you can't inherit. If you can't inherit, you can't be the posterity of anything, which means you do not have the protections of the Constitution automatically right there in one document. Sorry, you're not a member of the posterity. You're a bastard. You can't inherit. Tough shit. See how they did that? Sneaky, huh? Next one, exists under statutory law. True. Creature of the state. True. Separate legal personality. Yeah, I guess in a sense, your estate is technically a separate thing. And by the way, there's a lot of other trusts that they create out of the res of your estate that also have all of these various different types of, sometimes all capital letters names and sometimes not. Like sometimes you'll see Doe, John Henry, or sometimes you'll see John Doe like it is here, or different parts of it will be capitalized. And they might be different trusts that are just simply using the res of the estate. As I said, the first estate is the name on the BC. Don't ever forget that. Last one, subject to maritime amnesty law. Well, yeah, in a sense, not. Yeah, is the entity subject to maritime amnesty law? No, the commercial instruments that control the res of the thing are subject to maritime amnesty law. Technically, they're subject to all the jurisdictions, which they use, obviously, against you, all of them. Whether it be, well, I'll just run down what the 5 are in Anglo-American jurisprudence. So there's common law, there's equity, which deals with contracts and trust matters. Then there's maritime amity, which deals with banking and merchant affairs, and also you could consider that being part of the law merchant, even though in a sense part of the law merchant also deals with equity too, so it's kind of a dual thing there. And then military, and then ecclesiastical. So there's 5. Now, technically, the law merchant I did not add as one of the 5 because it technically isn't, but it's kind of shoved into, like I said, it's kind of shoved into maritime amity. So again, the 5 are common law, equity, maritime amity, military, ecclesiastical. That's it. Those are the only 5 jurisdictions of Anglo-American jurisprudence. Okay, let's finish out. All right, let's finish out the rest of this section here. Okay, so from the diagram, while you are technically a person, no, you're not, you're people, you've entered into contracts that you're completely unaware of. Right, well, somebody entered you into a contract before you were even aware of being aware. That's the birth certificate contract. Social security number, etc. Notes legal researcher Irwin Schiff, the distinction between natural persons and corporate entities, firmly established in case Hale versus Hinkle and Wheel Steel Corporate versus Fox, creates a legal framework in which different rules apply to each, right? Hale versus Hinkle is a good case where it actually, I believe it does actually differentiate between persons and people, as I recall. And Hale versus Hinkle is also a fascinating case anyway, because it deals with the grand jury. So I would highly suggest everybody go read that case. It's about the power of the grand jury. Some legal analysts have questioned whether standardized identification systems effectively create a separate legal person distinct from the natural person, a concept sometimes referred to in legal theory as a legal fiction, through which government agencies primarily interact with citizens. This is just saying that when you go and do this, what they just described here, I need an identification. I'm a baby. Look, I'm now acting as a trustee of what I should actually have claimed when I came of full age, proving that I haven't come of full age. By the way, becoming of full age means that you know how to handle your own affairs, okay? Which is something that we do at the Vocational Science of Freedom. We make sure that you do a proof of life and proof of age inquest done by a judicial coroner. So that ends the matter once and for all. And anybody out there that's arguing that, oh, we got to go to the state to do this. We don't do it by the state. You establish and ordain whoever you want to be your own judicial coroner, okay? You're not going to a court to do it. You create your own court to do it. You have 12 other people sign off on it. They're the petit jury. You have your coroner. Done deal. Why can we do this? Because it says so in the Magna Carta. Matters dealing with life and limb shall be considered gratis and shall not be denied. Period. Full stop. So if you're sovereign, and it's a matter of life and limb, and I would assume your entire estate, including your body, is a matter of life and limb, then they must be considered gratis and they may not be denied. Done. So, to continue. While this interpretation remains outside mainstream jurisprudence, the documented legal distinction between natural and juridical persons provides context for examining how administrative systems categorize and process citizen identity. True. This legal distinction finds further support in the landmark case Santa Carla County versus Southern Pacific Railroad, 1886, in which the Supreme Court's head note famously declared that corporations are persons under the 14th Amendment. Right. That was them coming over the top to say, well, corporations, we have to have rights too. While the court itself never explicitly ruled on corporate personhood in its official opinion, this head note nonetheless became foundation for over a century of jurisprudence treating corporations as legal persons. Treasury regulations further codify this separation between natural persons and legal entities. Department of Treasury publication 1075, Tax Information Security Guidelines, establishes protocols for handling taxpayer identifying information through standardized formatting, including the use of capitalized names on official documents. Right, because they can never actually change that when they put it into their little system. It always just comes out as being all caps. Meanwhile, UCC, oh God, here we go. Subsection 1201 defines organization to include legal representatives in a way that some legal analysts suggest could encompass the registered legal identity created through birth certification through mainstream legal interpretation differs on this point, right? That's not what the UCC is doing. The UCC is basically saying the organization or legal representative, that's you walking in there as a trustee and not as the sole lawful heir and the executor. Okay. The formalization of citizen identity through documentation has evolved substantially over the past century. Research demonstrates that birth registration systems serve multiple government functions beyond vital statistics. Right. As in making sure to keep you an infant. Establish citizenship status, enabling taxation tracking, and facilitating social welfare program eligibility. I.e., please, baby, may I have a cookie in the form of a benefit? Because if you take a benefit, you are abstaining from being the heir. It's called beneficium abstinente. Go look it up. The formalization of citizen identity through documentation has evolved substantially over the past century. Research demonstrates that birth registration systems serve multiple governmental functions beyond vital statistics. You already said that. Establishing citizenship status, enabling taxation tracking, la 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 la. This distinction manifests in how some legal systems interact with individuals versus their documented identities. When institutions address your name in all capital letters with a little title, Mr. or Mrs., they are effectively engaging with the legal fiction rather than the natural person. No, what they're asking for is who's the trustee of this thing. This creates a functional bifurcation where administrative systems primarily interface with the paper entity created through registration. In a sense, that's true. While the flesh and blood individual exists in a separate legal framework, right, under common law. A subtle but profound shift that fundamentally alters the relationship between citizens and governance structures. Yeah, in a sense, that's right. I mean, you're either subject to statutes, acts, ordinances, and codes under Roman civil law, or you're not, because you're sovereign. I should add a caveat to that. As long as you don't have contracts, trusts, pledges, bonds, and oaths that subject you to statutes, acts, ordinances, and codes under Roman civil law. There, that's correct. All right. While mainstream legal interpretation views these systems as administrative necessities, some legal theorists like Mary Elizabeth Croft, you ever read her book? It's kind of fun, have questioned whether the standardization of naming conventions in official documents, including the use of capitalized names, signifies a more fundamental shift in the legal relationship between individuals and the state. These questions, while speculative, reflect broader concerns about how administrative systems increasingly mediate the relationship between citizens and government. Right. If you ever want to get curious about that, go look up the Chicago Style Manual and then start to get into what all capital letters writing is. It's called American Sign Language. Not kidding, not a joke. Go look it up. These questions find contextual support. And by the way, you can see American Sign Language in every single user and license agreement that you've ever agreed to online. Just decide to go back and read one of them. There'll be a couple paragraphs in American Sign Language. Just saying. These questions find contextual support in specific Treasury operations. The U.S. Department of Commerce tracks birth certificates through the Census Bureau statistics of the United States reports. Each birth certificate receives a unique number that flows through the Federal Reserve System's bookkeeping as outlined in their Modern Money Mechanics publication. Again, what is the IMF doing? What are they trading in their special drawing rights between country and country? You just got your answer. This registration creates what Treasury terminology refers to as a certificate of indebtedness with specific registration procedures under Treasury direct accounts. Right, which people have been laughingly saying, oh, I'm going to get control of my Treasury direct account. No, you're not. You don't even have standing. You don't even have standing to claim your state bet yet, you stupid infant. And you're going to try and go mess around with the highest level of the law merchant system. Yeah, good luck with that. Anyway, to continue. While mainstream financial analysts interpret these systems as mere administrative tracking, UCC 9105 defines a certified security in terms that could potentially apply to registered birth certificates. Right, because they are. They're warehouse receipts. A birth certificate is a warehouse receipt. It has every single thing that a warehouse receipt requires upon it. Go look up the definition of a warehouse receipt in a banking dictionary. Not Black's, not Bouvier's, a banking dictionary. Warehouse receipt. Then go pull out your birth certificate. All those things will be on there. So the birth certificate is a negotiable instrument, or as I said, certified security. Also true. Where's that thing go? It goes through all of the banks of all the routing numbers, through all of the different E4s. Well, what the hell is an E4? I mean, like the Department of Agriculture, the Department of the Interior, the Department of, take your pick, all of the administrative state. That's where that thing goes through. And if you ever do get the original one, which there was a urban legend a couple decades back of someone who actually got their original back, supposedly, and on the back of it, supposedly, there were all of the routing numbers for all of those particular agencies on the back. So what did they use it as? They used it as a check to do what? For drawing on what? Special drawing rights. Again, back to the IMF, people. This is a global system, and it's been in place for a very long time, and none of you know anything about it. So anyway, to continue, which governs perfection of securities interest by filing a system that parallels birth registration process. Right. Some researchers, including David Robinson in his book Meet Your Straw Man and Whatever You Want to Know, propose a legal theory suggesting that birth certificates create a separate legal entity, sometimes called a straw man. Again, this gets dangerously close to, oh, it's a corporation. No, it's just your state. That's all it is. While mainstream legal perspectives and court decisions have consistently rejected these interpretations. Right. If you go into a court and say, I'm in control of my straw man, the judge is going to be like, you can go to a psych ward. However, if you walk into a court and say, Your Honor, I'm the sole lawful heir and executor of the res defendant estate, that is a problem for him. Two different ways to deal with it. One's at law, and one is dealing with retardation. Proponents point to the particular use of the all capital letters in government documents and the assignment of numerical identifiers as evidence for this dual identity framework. Right. If you want a full accounting of your estate, get your Nubident printout, also known as your master file from the IRS. That's every single transaction and all of the securities and all of the times that the thing's been exchanged and how many Abram tanks are in your fucking name. Okay. Get a hold of that if you really want to see the accounting. If you're thinking this sounds far-fetched, I understand. The more moderate interpretation sees these identification systems as primarily developing to meet practical governance needs, standardizing citizenship records, enabling social services, and creating consistent legal identities. Rather than as financial instruments. Yet even this pragmatic view acknowledges that these systems fundamentally altered the citizen-state relationship in ways most people don't fully comprehend. I had the same reaction. I bet you did. But before dismissing it entirely, I'd encourage you to examine your own documentation, the all caps name on your driver's license, the statement on your social security card declaring it remains property of the government agency that issued it. The frameworks we're discussing are hiding in plain sight in documents we interact with daily, but rarely question. It's important to acknowledge that courts have consistently rejected these interpretations on both procedural and substantive grounds. And constitutional scholars maintain that birth certificates develop primarily for practical purposes, tracking demographics, establishing citizenship, and enabling access to public services, not as financial instruments. Well, maybe some constitutional scholars might want to go back and realize that the history of law didn't start in 1776. Morons. Go back and look at what a settlement certificate is in England, which is the precursor to a birth certificate. I think you'll find something slightly different. While there is indeed a legal distinction between natural persons and corporate entities as established in Hale versus Hinkle, again, and by the way, I'll say one last thing about the natural person. What a natural person is defined as is someone who has the capacity for rights and duties. Not that they have them, they have the capacity for them. What does an infant have? The infant has the capacity for rights and duties. Doesn't mean they have them yet. Doesn't mean they've come of full age yet. So anyway, mainstream legal perspectives holds that this doesn't support claims about birth registration creating financial collateral. Okay, fine. Just again, go look up what a warehouse receipt is. Nevertheless, the development of these identification systems and the expansion of banking frameworks did take place in parallel and enabled novel, administratively mediated relationships between individuals and the state. You betcha. Birth certificates also used to specifically say, this may not be used as identification. And yet every single moron walks into the DMV and says, here's my birth certificate. I want a license. Okay, baby. You really want your license? Here it is. These abstract transformations have concrete impacts on citizens' daily lives. Consider property taxation. While the constitutional framework treated property ownership as a fundamental right with strong protections, today's administrative process can result in government seizure of a family home for unpaid property taxes. Yeah, again, that's contractual. You can get out of all that by removing the contracts and specifically removing your property out of the Torrens registry system. But that's a whole nother class. Even if entirely owned by the family and no outstanding mortgage, right? Again, as I said, you got to get rid of the registration part. Often with minimal judicial review, right? Because you're not in the right court. You're wandering into equity. You're trying to argue this shit in equity courts, of which there's all these presumptions over top of you. That's not where you do it. You do it in a court of record. A court of record proceeds according to the course of the common law. A court of record has its own seal, which is your house seal. A court of record can fine and imprison for contempt. And a court of record actually keeps a record, unlike what equity courts do, which is like they pretend to keep a record. And then when you ask for the record, they're like, we don't have it. But to continue. This astonishing reality means a homeowner can lose their full equity over relatively minor tax delinquencies. Really? No, you're not a homeowner. If you fucking registered something, you don't own it. God damn it, you morons. Get this through your head. I'm sick and tired of people not understanding what Roman civil law does. You bow to Caesar when you register something. I don't give a damn if it's your house, your motorcycle, your gun, or your child. You give up ownership of it so that Caesar can protect it. That's why 9/10 of the law, right? Ownership is 9/10 of the law. You ever question what the last tenth is? It's registration. For fuck's sake. Anyway, over 5 million Americans face property tax foreclosures proceeding in the past decade. Right, because we don't have courts of record anymore. And nobody knows what they're doing. Illustrating how administrative efficiency increasingly supersedes right-based ownership. Well, you gave away your rights because you registered the damn thing. These systems taken together make up the foundation for what I've previously described as a comprehensive architecture for tracking human activity. Yeah. From financial transactions to medical histories to physical movement, marking a profound shift in how governance structures interface with human life. The documented evolution of identity administration from optional recording of birth, from optional, it's your option, your choice, your will. Because without will, there is no property. From birth to mandatory registration with unique identifiers represents a fundamental reshaping of the individual's relationship to the state. As we'll explore next, these systems created the administrative infrastructure necessary for implementing large-scale governance changes through legal frameworks, that few citizens would ever directly examine. Right. Apropos the Edward Mandell House quote, we will hold the security interest over them forever. Remember that. Remember, he said that. It is not necessary to accept the more speculative aspects of the strawman theory in order to observe and consider how the increasing documentation and registration of citizens coincide with expanding financial systems. True. The growth of birth certificates, Social Security numbering, the taxpayer identification system did create new ways of categorizing and tracking citizens that closely aligned with significant changes in banking and finance, a documented correlation worth examining regardless of one's interpretation of its meaning. Right. Again, Ibid said, quote, they will be forced to register and be given what? Yeah. This legal fiction concept has deeper historical roots than many realize. The Sestake Act of I'm glad he brought this up. The Sestake Act of 1666, passed by the English Parliament following the Great London Fire, which happened 10 years after Oliver Cromwell let the filthy Luciferian Jews back into England because they'd been ousted by Edward I under a royal decree up until that time. It was called the Edict of Expulsion. Get the fuck out. And of course, Cromwell had absolutely no authority whatsoever to overturn a royal decree. But, since the Luciferians were in control and they pretty much just did a burnt sacrifice of 70,000 homes and God knows how many people. Yeah, they were pretty much in control. But I digress. Statuscorrection Act established a framework for treating someone as legally dead while physically alive. Another presumption that we get rid of in the vocational science of freedom status docs, because it's a proof of life and a proof of age inquest. Okay, when a person was considered lost beyond the seas or otherwise missing for 7 years, 7 years, right? When do you usually start kindergarten? They could be legally presumed dead, creating one of the first systematic distinctions between physical existence and legal status. Yep, exactly. Legal historian David Seep notes that this created a framework where the statuscorrection vi, which statuscorrection vi literally means for the life of the other, by the way, the beneficiary of a trust, well, that's another way of putting it, but it's not technical correct Latin, could be legally distinct from their physical person. Right, because it creates a trust. While originally addressing property rights during periods of significant displacement, this concept of legally constructed identity separate from the natural person established a precedent that would latter influence modern legal frameworks. Right, it's the force of creation of a trust. See, you have an estate when you come into this world. An estate, your estate, is everything that you own in law. That's your body, that's your dog, that's, wife and husband, your children, your computer, right? Your land. That's your estate. So what does Roman civil law have to do? What does the filthy cult of Rome have to do? What do the attorneys have to do? What do they have to do? They have to somehow get you into an equitable arrangement, some sort of trust arrangement, which splits the title so that you don't have control over it anymore, or you can be hoodwinked out of realizing what happened. And that's exactly what they did in the Statuscorrection Act. And if you want to go way farther back in history, it's what they did during the burning of Rome and the creation of the 12 tables. You can thank Nero for that one. But anyway, back to Britain here. All right. So British parliamentary records confirm this act remains active law. That means it's common law. Now, do yourself a favor. Go start reading some state statutes regarding common law. And you'll find that the common law of England is still in full force and effect here, unless what? Unless specifically repealed. I don't see a lot of repeals of the Statuscorrection Act anywhere. I'd be happily surprised if anybody wants to, present me with some, but haven't seen any yet. Not to mention the Statuscorrection Act is specifically stated in the DC Municipal Code several times, by the way. All right, but anyway, with amendments recorded as recently as 2009 through the Perpetuities and Emoluments Act. Is that DC? I bet it is. Oh, no, it's UK government. Okay. So yeah, they're just saying that it's still rolling along. Yeah, of course it is. This historical development represents an early example of the legal system's capacity to create distinct personhood categories that operate independently from natural existence, a concept that would evolve significantly in later centuries through corporate law and administrative governance structures. Right. Okay. We are way past an hour. So I think I will stop here. I will make a mark here for natural persons and corporate entities. This should be some interesting reading and more analysis when we get back. Anybody in chat want to comment, question, elaborate? So at least, are you guys finding this slightly fascinating that this guy's pretty much come to the conclusion that a lot of us have, and that I think going through this article with what he's found compared to what the rest of us known is a very interesting way to present this to everybody else. Janice, what does ibid mean? Ibid means basically, I have like an exact Latin, but it basically means, I've said it already, and when I said ibid, I was referring back to the quote from Edward Mandell House. So if you make an argument, say you're in open court and you make an argument against something, blah blah blah, and then the same thing comes up, or say the district attorney tries to bring it up again, and you just say, objection, Your Honor, ibid, meaning what I already said regarding this matter. That's all it means. Spectre said, I recorded all this way through just today in just under 2 hours. Oh, okay. So you read the whole thing through in class. Okay, cool. Yeah, I'll go watch your interpretation of it as well. So then we can kind of like, both of us will have a good layout for everybody to take a look at. Mine will be the more extended, verbose version, I'm sure. Amaru said, put up the Webster's Dictionary definition of crypt, a subterranean cellar cave, especially under a church for internment of persons, also a subterranean chapel or oratory, and the grave of a martyr. Yeah, maximum of law. No harm is done in things long acquiesced in. Right. If you're considered dead for a very long period of time, no harm is done because you've pretty much acquiesced into it. Another way of putting that too, well, not another way of putting that, but another important maxim regarding all of this is the maxim of law that states, he who does not stand on his rights has none. So if you fail to stand on your rights, it's basically a maxim of law that says you don't have any, because no one else is going to do it for you, because you're the only one that has the capacity and the standing, literally the standing, to do it. All right, unless there's anything else, anybody... Spectre said, silver is the money of gentlemen, barter is the money of peasants. Debt is the money of slaves. Yeah, I think there's another one too. Oh, gold is the money of kings. That's the other one you forgot. So, Robender said, individual is identified in the taxpayer and IRS code. Yeah, true. It's also automatically defined in 1 subsection 8 because a person is, they say that a person is an individual. Well, actually, it just says person, individual, and la 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 shall include every infant member of the species Homo sapien. So it's still an infant. So, okay. All right. So that looks like everything else for chat. And just for general information, if anybody wants to join the Vocational Science Freedom, join our Revolt server, which we share all kinds of fun and valuable information with everyone else on a free platform that's not censored. You can do so by going to the Vocational Science Freedom webpage, which is vocationalscienceoffreedom.wordpress.com. And you'll want to go and click on the welcome package, and then you download the welcome package and get your communication set up on Revolt and also on Mega. And Mega is where we hold classes. So once you get vetted, then you can join the Mega server and you can interact with us also on the Revolt server. And as far as the next classes are concerned, we'll have a Wednesday night open roundtable this week, which have been fun. They've just been recorded, and I'm not going to post them, nor am I going to stream those roundtables. They're just going to be for people who are vetted members of the VSOF. And again, all you have to do to get vetted is just fill out your welcome package and send it in. And I hope all of you guys enjoyed coming, and I hope all of you enjoyed reading. Also, just remember, make sure to download the timeline doc, because it's definitely worth the read, and watch the timeline class, because it is an all-day class, and it'll probably take you a few sittings to go through, but it's definitely worth it. All right. So with that, have a wonderful rest of your weekend. Have fun grilling out tomorrow. It's supposed to be a good day across America. And I will see the rest of you guys on Wednesday. And until then, stay safe and stay sovereign.